from Al Jamar, a member of the National Assembly. We will be receiving responses from the Department of Justice on the maintenance bill. That is a private member's bill that was sponsored by Honorable Hendricks. Welcome, Honorable Member, and welcome to the members of the Department of Justice.
Thank you very much, and good morning to you, Honorable Chair.
Thank you very much.
Ufrizile, Chair.
I was kicked out. I'm now back. I'm using another gadget. Committee Secretary. Bonani, who's leading us from the Department of Justice?
We have Mr. Sibelemecha on the platform. I think he is the one who's going to take us through here.
Good morning. Good morning, Chair.
Good morning.
Yes, I'm just checking. I was trying to switch the network because I see it says my network bandwidth is low, but I will proceed until maybe if it interrupts. Just a second as well, if I could share the responses, if you permit. Is it visible, Chair, from site?
Yes, yes, it is.
Okay, thank you, Chair, and good morning, and to honorable members, good morning as well. The response them, and I'll do it. But
the network is very bad. We can't hear you.
Honourable Chair, I just want to request if they could make the presentation a little bit bigger because it's very small.
Okay.
Maybe, yeah, it's on the font I see is on 11. So if they can maybe also increase the font. Thank you, Chair.
Now, but then the overall review of the Act will however consider these cosmetic issues when the new bill is drafted.
Mr. Lubamacha, one, your font is very, your font is very
Oh,
small.
it's very, okay, okay.
And
Is it
secondly,
better now?
yes, can you deal with your network? Because we could not hear you.
Maybe, yeah. Okay, let me switch to 3G then if you give me 2 minutes, check.
Okay.
Thank you, Chair. Chair, am I audible?
Yes, you are. You are. You can proceed.
Am I audible?
Yes, you are. You are audible.
Okay, thank you, Chair. Okay. Yes, I was just indicating that. Yes, Chair.
Proceed.
Okay, thank you, Chair. I was indicating that I'll be making responses in respect of each clause, and at the end of the responses will also give an overall response to the entire bill. In clause 1, we note that the bill proposes some change in the renumbering, and also there's a deletion of number 1 in front of the introductory line. And as the department, we view this deletion as immaterial regarding the overall interpretation of the Act and does not create any interpretation challenges. And however, we're saying when we deal with the overall review of the Act, we'll consider the cosmetic issues that the new, as we draft the new bill. It is also proposed that Roman numerals in the definition of section be removed, like that in Roman numerals in the definition sections from what we have checked. It is also proposed that a definition of complainant be added to the Act. However, we do not support this view in that the intention of the bill is to support an individual who is legally entitled to claim maintenance from the person who owes the duty of support, and not we should not extend the applications for maintenance to third parties on behalf of beneficiaries, as we create an unintended consequences, such as whether the money received will actually be used for the benefit of the beneficiary. In the discussion paper 157, which was developed by the South African Law Reform Commission, also discusses this issue on many levels. It proposes that Maintenance Act be amended to insert the definition of an applicant or a complainant in Section 1. The study further describes the applicant or complainant as a beneficiary, a parent, or another legal or primary caregiver of a beneficiary, or a teacher, traditional leader, religious leader, and an employer. This description for us takes the proposal beyond in-depth research geared towards overhaul system. Being
Mr. Sibili Mecha.
in the Law Reform Commission. Yes,
Mr. Sibili Mecha.
Yes, I can hear you.
Your line is bad.
It's bad.
It's on breaking.
Okay, let me try again to see what I can do.
Maybe what we can do,
Yeah.
we will proceed with the two reports.
Okay.
Maybe in the next 10 to 15 minutes, just try and find a better solution to your problem, and then we will come back to this maintenance bill.
Okay, thank you, Chair. I'll do so. Thank you.
Thank you very much. Committee Secretary, maybe let's proceed with the regulations, the report on the regulations, before we go back to the maintenance bill. Honorable Hendricks, we will just allow Mr. Sibili Mecha from the department to fix his network, and then we'll go back to the private members bill. Sorry for that. Members, this report was circulated to all members. Hello? This report was circulated to all members. Therefore, it is taken as read. It's the report of the Portfolio Committee on Justice and Correctional Services on the draft regulations for approval submitted in terms of Section 94, subsection 3 of the Legal Practice Act of 2014, Act number 28 of 2014, dated 15 March 2023. Are there any corrections on page 1? On page 2, is there a mover for the adoption of the report?
Chair.
Honorable Chair.
I move for the good morning, Chair and the members. I move for the adoption of the report.
Thank you very much. Is there any seconder? Honorable Masaba Jalamos, is there a seconder?
Honorable Chair, my hand is up. I'm not seconding. I would just like to see page 2 again, please. There's something that reads badly in that final paragraph.
Let's go back to the final paragraph. Committee Secretary, let's go back to the report, the final paragraph.
The committee recommends that the National Assembly approve draft regulations for approval it's just, reads poorly. That's fine.
It's
Thank
fine.
you. Yeah, thank you.
Thank you very much, Honorable Breitenbach, for that. Any seconder to the report?
Good morning, Chair. I second the report.
Honorable Ramon Ubeng seconds the report. Any objections? No objections. The report has been agreed to. The next report. The report of the Portfolio Committee on Justice and Correctional Services on the draft regulations for approval in terms of Section 94, subsection 1 of the Legal Practice Act 2014, Act number 28 of 2014, dated 15 March 2023. Any corrections on page 1? On page 2? Is there any mover for the adoption of the report?
Chair, I
Honorable
move for, yes, I move for the adoption of the report. Chair. Thank you.
Honorable Maseko Jele moves for the adoption of the report. Any seconder?
Honorable Neo Druchen seconds the adoption of the report, Chair.
Honorable Newwood Johan second for the adoption of the report. Any objections? No objections. The report is agreed to. Thank you very much, members. We have adopted the two regulations. They are ready to be debated in the House. Will I be correct that we will just do declarations, or do you want a full debate?
Sorry, Chair, please repeat that.
Would I be correct that we would prefer declarations than a full debate?
Oh, hell yes, please.
So any objection to the declarations, to parties being allowed to just do declarations instead of a debate? No objections. We agree to the declarations. Thank you very much. Mr. Sibelimecha, are you fine now? Mr. Sibelimecha?
I'm sorry, Chair.
Are you fine now?
No, it's here, Chair. He's I think he's been kicked out of the meeting. He's joining now.
He's joining. Okay.
Yes, we've just accepted him in the waiting room, so he might be in.
Oh, okay. Maybe let's have a 2 minutes break. We can start at 9:51. Will that be fine? Let's come back at 9:51. Can we proceed? Over to you, Mr. Sibili Major. Mr. Sibili Major.
Thank you, Chair. Am I audible?
Yes, you are.
Okay. I'm not sure if I should go back to the beginning or where should I
please.
start? And
Just
I should start from the beginning.
Yeah.
Okay. Yes. Clause 1 proposes some technical changes with regard to the numbering, and as well as basically the cosmetic issues which we are saying they don't have an effect on the interpretation of the act. Therefore, we will consider this type of cosmetics as we draft a new bill. And if we could move a bit up, there are Roman numerals that are also part of the cosmetic changes that we are referring to, that we do not necessarily find those in the Gazette, but as well, mainly there's a definition that is being proposed of complainant. And this definition, we do not support as a department, in that the intention of the bill is that it should be an individual who's legally entitled to claim maintenance from the person who owes the duty of support, and not extend to applicants for maintenance to third parties on behalf of beneficiaries, as this will create unintended consequences, such as whether the money received will actually be used for the benefit of the beneficiary. We're making reference to a discussion paper 157, which is developed by the South African Law Reform Commission, which is currently conducting an investigation for the review of the Maintenance Act. And the review elaborates on the aspect of, elaborates on this aspect regarding complainant, as they also indicate that it ought to be amended. We ought to amend the definition of applicant or a complainant in section 1. And the discussion paper preliminarily indicates, let me put it this way, the discussion paper, the preliminary report, where a discussion paper is a preliminary report, where comments are published in a consolidated document and they are highlighted in there. So the study also describes the applicant or complainant as a beneficiary, a parent, or another legal or primary giver of a beneficiary, or any other person who has an interest in the well-being of the beneficiary. And this includes, but is not limited to, a relative, a social worker, a healthcare provider, a teacher, a traditional leader, a religious leader, and an employer. This description, in our view, takes the proposal beyond the phrase legally liable. And it is advisable, it is on this basis that an in-depth research geared towards overhauling the entire maintenance system in South Africa is being conducted. It is advisable to await the finalization of the investigation by the South African Law Reform Commission before we make piecemeal amendments. The Law Reform Commission is currently preparing a report which will incorporate all the comments received on the discussion paper. And preliminarily, the recommendations that are being proposed are as follows. The maintenance matters should be treated as urgent matters, and that a presiding officer must play an inquisitorial role at the initial stage. Once the maintenance matter is lodged and proof of income of the person legally liable to maintain is available, the matter should be taken to the court on the same day or at the earliest possible date, so that the court may make an interim maintenance order where emergency monetary relief is granted in cases of economic abuse. See In circumstances where there is no order and proof of the financial circumstance of the person legally liable to maintain, which has not been supplied by the applicant, or where there is an existing order, the Act must provide for ex parte applications for maintenance for a court to make interim maintenance orders to cap instances where the delay may jeopardize the well-being of the maintenance recipient. In D, the maintenance court may make interim awards for emergency monetary relief in terms of the Maintenance Act. E, the maintenance court be empowered to hear ex parte application and make interim maintenance orders as it will provide immediate relief for applicants. And F, lastly, all maintenance matters should be regarded as urgent and they may be brought outside court hours if circumstances warrant. The report of the South African Law Reform Commission will make the final recommendations of the review of the Maintenance Act 1998 by June 2023. In respect of clauses 2 and 3, we noted that in clause 2, there is an incorrect referencing, and that reference, it is proposed that section 6.1b Roman 1 be amended, which does not exist. The drafter appears to have wanted to amend section 7.1b instead. In that case, we are aware of the view that the proposed substitution of the word complainant being the definition proposed is not supported for the reasons that we have indicated above. The drafter further proposes that section 7.2 and 7.3.1 Roman 1 be amended to reflect the term complainant throughout the provision. Again, we noted that this is an incorrect referencing. The provision earmarked for the proposed change is actually section 6.2 and not 7.2. Even in that case, the proposal is not supported due to reasons that we have indicated above. A person to be maintained, or the person in whose care the person to be maintained resides, carries business, or is employed, is broad enough and covers all eventualities and provides a wider scope. By replacing all those with concept complainant as suggested, narrows the scope. In clause 3 and 4, there is a proposal to amend section 7.1 Section 7.1 and 9.1 to specifically delete the word may and replace it with shall. The proposal, in our view, curtails the discretionary powers of maintenance officers that they currently have, and this will make the provision peremptory and without an option to consider alternatives. The maintenance officer must have a discretion to enroll an application or not. The proposal will render, in our view, the provision cumbersome to implement, and therefore we do not support the proposal. In respect of clause 5, it is proposed that the phrase "and complainants" be added to the heading "Rights and Privileges of Witnesses." It is tried law that a witness who is subpoenaed to assist the court in testifying in court on an issue are legally entitled to a witness fee. The fee is to defray the cost of travel to and from court. The Maintenance Act already makes provision for this in section 11. And then in clause 6, the proposal seeks to insert a section that deals with alternative dispute resolution mechanism, and the Act makes provision for the appointment and powers of maintenance investigators and maintenance officers. These powers establish a process for the taking of statements and the gathering of information on the financial position of the parties, amongst others. The Act makes provision for assistance to a person claiming maintenance and the person under a legal obligation to pay maintenance. The inquiry envisaged by the Act culminates in an order by the maintenance court. Adding another layer of alternative dispute resolution may delay matters and work to the disadvantage of the parties. This proposal may also result in a further financial burden on the parties. Therefore, the proposal is not supported. And finally, the submission of the department is that the maintenance system in South Africa is a complex phenomenon which is currently undergoing review. Therefore, it is not advisable to effect piecemeal amendments before the review is completed. Some proposals will result in financial implications, while others are based on incorrect references to the Act. The department does not support the bill for reasons that are set out in this document. And I thank you, Chair.
Thank you very much, Mr. Mabileta. Members, any comments or questions?
Chair, before members comes in, can I hear the last statement of Mr. Madimecha or Madimecha? The last statement, what is it? The department does what?
Mr. Madimecha?
Thank you, Chair. We're saying the department does not support the bill for the reasons that we have indicated in the responses. Thank you. I'm not sure if that was the part.
Yes, thank you very much. Okay.
Thank you. Thank you very much, Honorable Mr. Sibili Mecha. I have the following members: Honorable Nebo Druchen, Honorable Werner Horn, in that order. Honorable.
Good morning. Good morning, Chairperson, and good morning to everyone on the platform. Chair, I don't really have questions related to the presentation itself, but I have clarity-seeking questions. In the first paragraph, in relation to clause 1, it says, an overall review of the Act will consider these cosmetic issues when a new bill is drafted. So clarity in terms of that, will there be a new Maintenance Act? Is that what is meant by this? If they could just clarify what the new bill part means. That's all I wanted to ask, Chair. Thank you.
Thank you very much, Honorable Horn.
Thank you, Chair, and good morning from my side to all colleagues. Chair, I want to inquire about the advice that we must await the finalization of the Law Reform Commission process, discussion paper 157 as mentioned, which deals with a review of the whole of our maintenance regulatory and legislative framework in this country. The difficulty with this, whilst on the one hand, obviously do not want to expend energy as the committee to do stopgap amendments if a proper overhaul is on its way. The difficulty is, however, that this overhaul has been promised since 2016, when in the previous parliament, certain small amendments were effected to the Maintenance Act. It's been on the legislative agenda of the executive since that time, but as we sit here in 2023, 7 years later, there's still no sign of the final product or the new bill. So it becomes a challenge to accept the advice that for practical reasons we must not proceed with even the good proposals in a private member's bill if the end is not in sight really regarding that let's say research project as it's called. So I would want to inquire whether there's any firm dates which we can look towards or forward to before we as a committee can make an informed decision to accept that piece of advice. Thanks.
Thank you very much, Honorable Horn. I saw a hand of Honorable Hendricks.
Thank you very much, Honorable Chair. I'm obviously very disappointed in the response of the department. However, I would like to thank the other two speakers for raising very important issues. And we've heard about the 7-year delay. In fact, it's a 25-year delay since 1998, and not a day longer. Those who have been harmed by issues in the legislation, I don't think that they must wait a day longer for relief. But having said that, I would like to acknowledge the presence of Mr. Prince, who helped me to draft this bill on behalf of the parliamentary legislative drafting team. And I understand that he's also available if the committee so desires to address any constitutional, procedural, or legal matters. Let me turn now to the department's comments received on my maintenance amendment bill, and I ask Honourable Chair for indulgence, because we spent a lot of time and money and effort on this, and to have this rebuttal, a very sloppy response, I think you must give me opportunity to deal with it in a lot of detail, and apologize and I take the time of the committee. So I'll deal with the substantive comments. I don't want to waste the committee's time on the slip up on numbering except to apologize, but that can easily be fixed. The department is more concerned about Roman numerals instead of the crux of our amendments, which aim to address the gross discrimination currently suffered by women, largely mothers, which is one of the major contributors to violence against women and children, namely financial dependence and vulnerability. Yesterday, the African National Congress submitted a motion in Parliament to address patriarchy. Yet we find that the department is itself perpetrating this gross discriminations against women and children by providing fathers with a transport and accommodation allowance. Yet mothers and children who desperately need such relief are not provided equally with such an allowance. These mothers are left to take of their already limited resources for school fees, electricity, and a proper meal for the children to pay for their commuting costs to the court. This problem is even worse in rural villages and areas which are far from the courts. Do those in the ivory tower simply not care about the plight of these women and children? Do they simply shrug off their constitutional duty towards them and hide behind disingenuous arguments? In 90% of cases, the person seeking maintenance is the mother, because of the primary caregiving duty being placed on mothers. These matters are subject to constant postponements because fathers don't show up or simply don't bring the documents that are required to bring. This happens over and over again, and mothers have to fork the bill in this cat and mouse game despite their vulnerable financial position. These women, in many cases, violently abuse and hurt, and through all that, she has to fight to put bread on the table for the child which the father does not support. What a disgrace which the Justice Department ignores. The department protests that giving money to mothers like they give to errant fathers is going to add to their budget. How can an objection be raised where it is a constitutional duty to ensure the remedy? The whole point of the Act is to assist in such instances. This should be budgeted for in any case because there's a budget for witnesses which can be tapped into for these purposes. It is not enough that we pay lip service to the rights of women and children 3 months in the year in Parliament. Then we commit such atrocious discrimination and harm to these very same people through laws which are grossly discriminatory. Clause 5 therefore addresses the problem that the respondent, defendant, and witnesses are being assisted with transport, accommodation, fees. Complainants are currently not accessing this statutory benefit. This is because the section is too vague, as stated above. It must be clear on who a complainant is and what rights and entitlements such complainant should have in the process. The definition of the complainant as a primary beneficiary is crucial in alleviating the prevailing hardships imposed on women and children. These realities and the fact that our amendments aim to rectify these wrongs is not only ignored by the department, but it misleads Parliament. It misleads you and me by stating that this allowance given to fathers is witness fees. The father is not a witness to the proceedings. He is a party. He's a respondent. If he gets this monetary relief, why not the mother or child complainants? This has been well covered by the media, and I want to put on record the support of the media who have shown empathy for children. We publish in the government gazette the wide-ranging experts and representative bodies concerned about the hardship mothers go through to get maintenance for their children. I respectfully submit that it doesn't appear at all that the department has applied their mind to the substance of the proposed amendments. It also appears they are not aware how the Act is being implemented or not implemented. The amendment bill hits these problems at its course. The law as it stands has glaring gaps causing the system to fail women and children. We have an obligation to address this, as other honourable members of Parliament did in 2016 and earlier. One of the biggest problems is the ambiguous and inherent reference to parties, which cause confusion among those meant to implement the act. This is the reason for including the definition and the references to a complainant and a respondent. This should be seen as distinct from a witness. With regard to the definition, the parliamentary legislative drafting team assisted me in this, and the parliamentary legal head had no quarrel with it. The Constitutional Oversight Committee showed support by issuing a constitutional certification. Further, in the plenary debate and presentation to this portfolio committee, no one had a quarrel with adding the definition of complainant to replace the current reference, which is a person, that any person legally liable to maintain any other person fails to maintain the latter person. The department in its own version sells this house in its attempt to mislead Parliament, that the Law Reform Commission supports the addition of the definition and reference to the complainant. After noting the department's stubborn rejection of the amendment, I consulted my national spokesperson, who was a family advocate dealing with the rights of children for decades under late Issa Mohammed, a former wolf of the ANC on this portfolio committee. She categorically told me that the word complainant is used in the courts and at all hearings, and not the word parties. So I don't know why the department stubbornly sticks to maintain parties. Yet the departments come to this portfolio committee and objects to the term, which will clear up the current confusion and egregious injustice which currently prevails. Let me share the legal opinion I got from my counsel to the objection and share the Constitutional Court reference so the department can withdraw its objection. And this is what it says: law should not be vague or ambiguous. In the New Clicks judgment, the court found that vagueness is a ground for review in Paja. Vagueness causes an act, an administrative action, to be unconstitutional or unlawful. This is based on the rule of law, which is the foundational value of our Constitution. In affordable medicine, the Constitutional Court explained that laws must be written in clear and accessible manner, and not parties. The law must indicate with reasonable certainty to those who are bound by what is required of them, so that they may regulate their conduct accordingly. This is not the case in respect of the Act. It is vague in its references to the parties involved in these matters, and does not indicate with reasonable certainty to those who are bound by it what is required of them, so they may regulate their conduct accordingly. The proposed definition is complainant means any person legally entitled to be maintained by any other person who lodges a complaint or on whose behalf a complaint is lodged relating to maintenance according to this Act. It will be made clear that complainant refers only to such person entitled to seek maintenance under the law rather than any third party. This amendment is aimed at legal certainty so that the implementers can understand what is expected of them towards those seeking relief. This is currently clearly not the case. We ask that the department withdraws this objection. Regarding clause 3 and 4, we find that maintenance officers simply tell parties to bring the required document information, and if they do not, the matter stands down indefinitely. After copious inquiries from the complainant, they then resort to verbal representation of parties which are not accurate. The mother has to try and collect the evidence for herself if she wants to speed up the case. This creates all kinds of risk to her safety. The process cannot be left to the discretion of the relevant parties, as the information that ought to be gathered through this discretionary process is critical, determining which course or remedy to employ, failing which any decision is at the risk of being irrationally or arbitrarily taken, which will cause more harm to the complainant's plights, as appears to be the case currently. The issues and hardships identified by complainants are legitimate and pervasive. The amendments seek to alleviate these hardships. The proposals are not difficult to implement at all and will only better ensure the object of this Act. Why lie to Parliament that South African Law Commission is sorting all this out? Why have we not had engagement on this before this bill was introduced? Why hasn't this committee been contacted by the Law Reform Commission? They saw these amendments in the Government Gazette. They didn't have the decency to comment or reply to say, guys, wait a bit, we are busy, and give us some hope. Now let me address the other misleading comment by the Department of Justice that the amendment bill is piecemeal and this has to be avoided. We cannot refer to these amendments or any other as piecemeal. We already have a comprehensive statutory system but there are gaps therein. There are vague and ambiguous areas which must be addressed. And people tried to address this in 2016 and even in 1998. The purpose of amendments is to fix these problems. It is therefore misleading and incorrect to refer to it as piecemeal. The department mustn't use its sloppiness and its lackadaisical attitude to try now and mislead Parliament. Lastly, this bill is not being introduced arbitrarily, and a lot of thought has gone into it, along with input by those who are affected by the Act's current failures. An unreasonable and undue burden will not be placed on the department as a result thereof. This approach will be maintained, and in this spirit, I turn to the dispute resolution procedure, which is currently proposed. Here, I concede that the department has a point that we should not add another tier to resolve complainants, namely that of arbitration. An honorable member of the DA did suggest that maybe this is an area that needs cleaning up, and it came to my mind that maybe she referred to, instead of just conciliation, also arbitration. In the CCMA, I've appeared in over 2,000 cases. The difference is that conciliators are trained and accredited to mediate properly between the parties. There has been a groundswell of concerns that maintenance officers are not properly trained to mediate disagreements with parties in their inquiries with the parties, because they are not accredited. They are not able to maintain their objectivity and impartiality as a result of this lack of training. That is one of the main problems with the system. The proposal is thus that maintenance officers should be formally and properly trained in mediation and mediation matters. But that's another matter. This will allow for the speedy resolution of matters at that level because they will be more decisive and empowered. We do not want anything to further prolong the plight of affected women and children. We mustn't wait a day longer. Rather, we need to speed up the process. So we will withdraw the proposal to add another tier, that is arbitration. Although we see that the average time period with which we say relief is granted is 7 years. That's unacceptable. We hope that these amendments are viewed with the same earnest consideration and commitment to addressing the plight of women and children as at which they were proposed. I thank you, Honourable Chair, for your indulgence. I know this is a lengthy response, but this is close to the hearts of mothers who are suffering. And like I say, we can't wait a day longer to give them cash to go to attend maintenance courts. Thank you very much.
Thank you very much, Honorable Hendricks. I see the hand of Honorable Masako Chele.
Thank you, Chairperson. Thank you very much. And thank you also to the department for the presentation. Chair, I think my colleagues has covered me in so many ways, but where I was sitting, it was the issue of, I think the department, I'm not sure if they're aware that how important is this bill. Is also the issue of completing whatever that they are doing. I think, Chair, it is very much disturbing to hear that they've been working on this for so many years, whilst the women and children are having problems. I think on the issue, this matter, Chair, I think one day I was talking to somebody about it, a woman who was really struggling to get the maintenance money from the office about this. And one thing that made me think that she raised, it was maybe these issues, the reason why some of these important issues are sometimes not attended to, it is because the people who are working with them, maybe it's just an allegation, Chair, that they're involved themselves. If we can go through, I don't know, I even laughed and said, Chair, if you are not going to take the issues of women and children serious and without discrimination, being also men themselves who are handling these issues, it can also make women to think like that they are not taking these things serious because some of them are involved themselves. If we can go into detail, it's just an allegation that somebody was raising. So I'm thinking now, Chair, that much as this bill is important, I think the department must give it guidance in terms of when are they going to finish what they are doing. Number two, whatever that the Honorable Hendricks has presented, is there anything maybe that clicked in their mind that would make whatever that they are doing right now with the bill that they are saying it is covered, some issues are covered in that bill that we don't have here, that we cannot say indeed it's covered, because right now, some of us, we were not there 7 years ago or more, as it was indicated. We don't know exactly deeper into those issues, Chair. So what are the issues, without them saying we reject this? Is there anything that came into their mind that enhances or enriches what they are working on, because we don't have it now? Because I think some of the points that he raised, Honorable Hendricks raised, they, to an ordinary person, they make sense. Maybe in terms of the law writing down, they might not make sense, but they make sense. I'll make an example, Chair. The issue of this one of saying, no, this is the third person, we can't give money to this person because that person, the money might not reach the child and all that. What is the department doing in keeping that? Because where I'm sitting, I was thinking, like, if that is not going to happen, what is the department assisting in making sure that that area, it is covered for? For example, I was sitting here that I was thinking that why can't we open the bank account, but the process must be handled by those people, those who are able to assist this child, but the money should go wherever they think it will be safe. And all. So those are the things that makes one to think that maybe the department has to go deeper into this issue, Chair, and look into it. And also worried, why does it take so long for them to finish what they are doing? Thank you, Chair.
Thank you very much, Honorable Yako.
Thank you, Chair. Sorry, I'm just a little bit on the road, so please excuse my background noise. I just wanted to know how long do they think it's going to take for this act to be overhauled, if they're saying that it's in the process of being overhauled, if it's been happening for 7 years. How long do they give us now for it to come to pass?
Thank you very much, Honorable Yako. Mr. C. Belimecha.
Yes, thank you, Chair. The questions, I think, mostly relates to the delays around the investigation by the South African Law Reform Commission. So we had communicated with the Law Reform Commission. If you could turn to page 2 of the response, just before, in the middle of the page, we have indicated that the report that will make the final recommendations of the review of the Maintenance Act will be ready by June 2023. So this is the indication that we have received from the Law Reform Commission. So that will then be having the final recommendations, which I have in the same page too, also indicated some of the recommendations that already the preliminary report or recommendations was indicating. So just sort of giving an idea of what would most probably be part of the things that are to be dealt with. And I could also indicate that the the issue of maybe the process from there will be that the report will be submitted to the minister who would consider, and the Law Reform Commission in most instances will prepare a draft bill that will be in line with the recommendations that they would have prepared. And therefore, once the report is processed by the minister, we will then, as a department, be like the chief director that I'm in, be given instructions to proceed with the bill. So the issue around the timeline of the bill, I might not necessarily have it now, but if the report is given to us, to the minister in June and is processed, so we'll be starting to engage on the draft bill and refine it in the sense. And just an indication about the seriousness of the challenges. I'm well aware of the challenges that the mothers, women and children are facing. And I'm also well aware that there is a process internally that the minister is engaged in respect of the improvement framework that they're dealing with, besides the review that is being undertaken by the Law Reform Commission. And I have noted the response, although I was missing some of the things because of the network, that Honorable Mr. Hendricks was indicating. And the reference to the legal opinion. And however, the one issue that I did not hear properly is Ms. Yako, but I started hearing in the beginning that the honorable member saying how long will the bill take, but I didn't hear the last part of it. But if that is related to when we'll be tabled the bill in Parliament, I think, as I indicated, that we are waiting the report by June. So we'll then process the bill thereafter, which in ordinarily will mean looking at the timetable of Parliament in the current sixth administration will then mean it will not be possible, but then in the seventh administration. But that is the indication that I'll also take back to indicate the agency that the honorable members are indicating that while we are not supporting the bill, it does not necessarily mean that we should then not process the bill that will be born out of the review undertaken by the Law Reform Commission with the speed that it will require. I think, Chair, I would, if unless I missed any comment that I should have responded to, I think I should thank you for now, Chair. Thank you.
Thank you very much, Honorable Horn, followed by Honorable Nevot.
Thank you, Chair. Maybe just to put it then on record, given our past experiences, it would mean that even if the Law Reform Commission meets that new target date of June this year, for the department ordinarily to settle on a draft bill, which they then put out for comment, thereafter it's taken to Cabinet, and thereafter the further draft is then tabled at Parliament. That process, in many instances, in itself takes up to a year. So it is a big question mark that must be put across the reaction of the department to say that we must await the finalization of the research if we are to take into account that would, for all practical terms, even if also if we take into account the fact that next year is an election year, be at the soonest, and then one is very optimistic, be end of next year before the next Parliament will then be favored with this bill. So the issue about the immediate plight that can be fixed through the private members bill and the specific portions of the members bill that can address the real issues immediately. The question mark is big as to why we should then await the finalization of the research. Thanks.
Thank you, Honorable Nevot. I would, members, appreciate a situation where members, when they speak now, after this round, they are more definite with what needs to be done, because it's a special procedure in how we deal with private members' legislation. I think after this round, members should speak to the way forward. Honorable Nivo Trochen.
Thank you very much, Chairperson. I didn't see the response to my question, but I wanted to ask if the department can email us the discussion paper 157, because I see here that they say the discussion paper is a preliminary report where comments are published in a consolidated document. So I would like to see what the report says and what the comments are that are there. But still going back to my question, do you mean that after June, when the minister has received this final document 157, only then will it be a new bill? So my question is, will it be a new bill eventually on the maintenance issue? Thank you, Chair.
Thank you. Mr. Spillemajor.
Yes, thank you, Chair. And I think as I tried to indicate that looking at the current, the elections to come in 2024, sorry, is that there is no possibility that a bill after the review will be processed during this administration, but then that could only be in the next administration. That indication I did give, just trying to indicate that the practicalities. But then further, and apologies, I forgot the question. Yes, indeed, once the review is done, I partially indicated that there will be a bill that will be developed in relation to, as a proposal by the Law Reform Commission, that will be submitted together mostly with the report to the minister to say, this is what we're proposing, recommending, and here's the bill that we think should be processed and developed. But then in that sense, the decision will obviously be taken whether it's a complete new bill that replaces the Maintenance Act altogether, or a comprehensive amendment bill that deals with the issues that are to be dealt with, as would have been recommended in the report. So definitely there will be a bill that will be processed to deal with the recommendations of the Law Reform Commission. That's the procedure usually they follow as they prepare the reports. And flowing from there, the minister will then have to process the bill that will deal with the issues that we are indicating are to be under review. Thank you.
Mr. Spillemajor, in terms of content, let's move away from the procedures now. In terms of content, is there anything in the content of this bill, even if it was to serve as an interim relief, that you think that you fundamentally differ with, or the South African Law Reform Commission, in terms of content, there is a big difference between what this bill proposes and what is coming?
Yes, Chair, if we could, for example, on page 1, what we have indicated is that there is an issue of the complainant being given for being paid. And we're also indicating that the Law Reform Commission has already as well proposed, or having looked at the insertion of the, or amendment or insertion of the definition of applicant or complainant, and that they in their study they describe an applicant or complainant as a beneficiary, parent, or another legal. So there is a research around that, and we're saying the manner in which we view the approach is that it tends to extend the scope. And in one line we had indicated that we should have a further research in order to deal with this aspect of remunerating or paying or defraying, let me use the correct word, defray the costs of the complainant. So this is something that we are saying it requires a careful research. Therefore, we would want to approach it in that manner, that we should not approach it in a piecemeal manner as we should be doing, so that comprehensively we deal with all the aspects. And if we, Chair, part of the preliminary proposals are that we should deal with maintenance applications as urgent matters in order to avoid the issue of the back and forth, going back and forth, where there is an issue of the costs that are incurred by those who are lodging applications for maintenance. So that's why we would not commit to saying currently the issue that is being proposed of defraying the costs, it is a broader issue for us, and it could be dealt with differently by making sure that if you go and make an application, that application can be heard there and there by a presiding officer in an inquisitorial stage at the initial stage, an inquisitorial role at the initial stage. So therefore, there is a broad discussion around the issue that we feel it should not be dealt with in the manner that it is being approached currently. Thank you, Chair. And we will ensure that we email the discussion paper and also the comments, which I'm not sure they might be in volumes, that the Law Reform Commission assists us to make sure that they are emailed or delivered to the committee secretary or secretariat. Thank you.
Thank you. Honorable Masoko Chela.
Thank you very much, Chair. I think what I'm hearing now, Chair, the responses from the department, it makes one to think that a way forward, I'm not sure if maybe it will satisfy everybody, or might be, we as a committee, we agree that let's leave this matter with the department and also allow Honorable Hendricks to also keep on watching as to where is the process is, because now we are having two different processes, and we need to consolidate them, and so that we have to watch this the process and the speed and or the agency about the matter for a conclusion, Chair. So I'm not sure. I was going to propose that let's give this matter to the department to deal with it and consider also the contents as you indicated further, and see how they can accommodate all those things that has been raised in the manner, because it seems as if Mr. Madmeja has they've got some ideas as to how to deal with those issues. So maybe they consult with Honorable Hendricks in terms of making sure that this is what they want to do. And then when they come back, we have one process, one bill, and then we are dealing with it, Chair. So in short, my proposal is that can't we just take this thing and give it to the department and then deal with it? Thank you, Chair.
Thank you very much. Honorable Hendricks, I'm not going to prioritize you first. I want to first hear, because you are the sponsor, I want to hear the other members on the way forward. Members, there is a suggestion that firstly, we have to wait for the report of the South African Law Reform Commission, which we are told that it will be in June. And two, that after the report, the department should also try and work also with Honorable Hendricks in ensuring that his inputs find expression in the comprehensive bill that would be drafted so that we don't duplicate the processes, because in both the process of the South African Law Reform Commission, there is the financial implications involved, and also there are also financial implications. Money's time has been spent also on the side of Honorable Hendricks. 3, that this process should be treated very much urgently, because ordinary people are suffering on the ground. But being that as it may, as Honorable Maseko Jele suggests, that we must find a way of ensuring that these two processes work together, but they are expedited. Honorable Horn has raised a valid concern on the time delays. Both Honorable Horn and Honorable Hendricks. Honorable Horn said that this bill has been on the offering for the past 7 years. Honorable Hendricks says that the process started in 1998. So that is generally unacceptable. And I do think that on a broader point, as this committee, we have to express our dissatisfaction with the way the South African Law Reform Commission works. We're dealing with the Transkei Penal Code, which took for 2 decades for it to come to, before Parliament. Certainly, it can't be correct that they just take forever to look at the law reform process. We know that the law reform process is complex, and there's a lot of research that needs to be involved, to be engaged. We know we're very much appreciative of all those challenges, but at the same time, it just can't be justifiable that you have processes that take 2 decades, especially those processes that affect our people on a daily basis and makes the administration of justice to be inaccessible. Be that as it may, the way I'm reading the discussions by members is that one, Honorable Hendricks has tried to respond to an immediate challenge that is facing our people. And there is this particular process by the South African Law Reform Commission. What we need to do is to say, based on the commitment that the South African Law Reform Commission has made, that by June they would be done. If they are not done by June and is just kicking the can down the road, we will have no option but to proceed with a private member's legislation as proposed, because as Honorable Horn has suggested that this has been coming for some time now. If by June that they have, notice us, that they have promised nothing happens, then the departments, parliamentary legal services should try and work with Honorable Hendricks to ensure that this bill proceeds. Because also on the side of Honorable Hendricks, he has made a concession that he thinks that issues around conciliation, they might need to be reworked. So let's allow that particular process until around June, hoping that the process, the report of the South African Human Rights Commission would be done by then. But for now, the first preference is for the 2 processes to work in tandem to ensure that we have a comprehensive maintenance process that is that also takes the wisdom and benefits of also the work that Honorable Hendricks has done. That would be how I'm reading the discussion so far. Honorable Horn.
Yes, Chair, I don't want to be disagreeable. I would, however, also think that another way in which we can approach this is to firstly see whether that specific discussion document is then, or research product is then published by middle of this year. As it is, we're now in the middle of March. We are about to go in April on a constituency break. So I don't profess to be totally in charge of the procedural aspects, but in my mind, there is the possibility of the committee also saying that we're staying the further processing of the bill to at least see whether the Law Reform Commission meets that specific deadline, because as you indicated, in respect of other matters which they conducted research on, there has been inordinate delays. So I don't know how Mr. Hendricks would feel and the rest of the committee if we, for example, decide to not, for the reasons I think you unpacked and the Honorable Maseko Jele unpacked, and which are sound reasons, to now already, I want to say, dispel of the private members bill, but rather to say, okay, let's then put it on ice until the middle of the year, and if that Law Reform Commission research outcome is not available by then, that we then again decide as to whether it is not in the best interest of those who are at the receiving end of the problems around the current maintenance framework to rather proceed with the bill. Thanks.
Thank you very much. I don't think we are disagreeable. I think, I think you have articulated the position well. Honorable Yako.
Thank you, Chair. Again, I apologize for the background noise. I'm just currently on the road. I think I agree with Honorable Horn in that we need to decide whether we are carrying on with the private members bill, or we're going to wait for the department to come back to us at a specific time with the reform bill, and then we move like that. That's what I wanted to know. What are we going to do?
Thank you very much, Honorable Jele.
No, it's a legacy hand, Chair. Thank you.
Honorable Jele, what do you say?
It's a legacy hand, Chair. I'll put it down.
Oh, okay. Thank you very much. I think, honorable members, I think that is, I don't see any descending hand. That Honorable Hendricks will stay the matter until that end of June, which would be the expected time that the South African Law Reform Commission would have reported on the comprehensive review of the maintenance bill. And then thereafter we will come and review our position. And after that time, when we come back from a recess, where if they have responded or they have not responded, we will take that into consideration in determining the way forward, because ideally it would be good to have the processes meshed. But if they have not met their side of the bargain, we will decide from then as to how we move forward. Is that fine, honorable members?
Chair,
Yes, Chair.
Steve Botcha, thank you.
Oh, Honorable Shorta, thank you very much. I thought you are in the.
I was. Yes, I was, and I just appreciate just catching the end part. I'm fully supportive of your view and grateful to Mr. Hendricks. I think at the stage in June, one can then look at the desirability of the bill. I think that's obviously the decision that we will take then. It seems a very worthwhile bill, but I support the committee's approach at this stage. Thank you, Chair.
Thank you very much, Honorable Hendricks.
Thank you, Honorable Chair, for giving me another bite at the cherry, short bite, I suppose. I'm obviously very disappointed because I feel that not a day longer must be wasted to give these children bread on the table. And I feel that, the motion of desirability should proceed with haste so we know where we stand. So, for example, if this is not a threat to anything, for example, if the committee decides not to support a motion of desirability so that we can proceed further, then obviously after that it will in any case be debated in Parliament. And then we'll have to see what legal options are available to assist children who for years now don't have bread on the table, and we now continue to suffer. And we have heard that the earliest time that a new act will come into place is possibly in the 7th Parliament, and also maybe in the middle of the 7th Parliament. I think that is a miscarriage of justice. Thank you very much, Honourable Chair.
Thank you very much. The matter is stayed until end of June, after we have received the report from the South African Law Reform Commission. If we do not receive the report from the South African Law Reform Commission, and then we will meet as a committee and chart the new way forward. Thank you very much, members. Members, the next meeting will be on Friday, where we will be discussing the certificate, the exemption certificate, and also adopting the report of the 18th Constitutional Amendment Bill. Thank you very much, members. The meeting is adjourned.
Thank you, Chair.
Thank you, Chair.
Bye-bye.
Thank you.
Recording stopped.